Immigration raid at Hyundai LG Energy site in Georgia, Sept. 6th. Primary sources: CBS News, Wall Street Journal, Financial Times, Reuters, AP News, Forbes, Wave Executive Summary. On September 4th, 2025, U.S. immigration and federal law enforcement agencies conducted a large-scale raid at Hyundai's construction site in Ellabell, Georgia, where an electric vehicle plant and an adjacent LG Energy Solution battery facility are under development. Approximately 450 individuals were detained, including multiple South Korean nationals, some identified as LG Energy staff on official business. The raid, jointly executed by ICE, Homeland Security Investigations, FBI, ATF, and Georgia State Patrol, was based on a judicial warrant tied to allegations of unlawful employment practices. While Hyundai's EV production continues, construction of the battery plant has been paused pending further investigation. This incident raises significant diplomatic concerns. Seoul has formally intervened, sending officials to assist nationals and demanding that U.S. enforcement not compromise bilateral investment trust. Strategically, the raid threatens the credibility of South Korea's $12 to $26 billion U.S. investment wave in advanced manufacturing, complicating Trump's broader industrial repatriation agenda. BBIU opinion: immigration enforcement, compliance failures, and Korea's strategic vulnerability in the U.S. The legal fault line: B1, B2 visas allow only short-term activities such as business meetings or tourism. They do not permit construction work, site supervision, or employment. Violations result in visa cancellation, deportation, and multi-year reentry bans. For legitimate employment, the visas required are H-2B for construction and temporary labor, H-1B for engineers and technical staff, L-1 for intra-company transferees, and E-2 for treaty investor employees. Processing takes 3 to 6 months, with H-1B subject to lottery. Non-compliance exposes workers to deportation and employers to fines and visa program exclusion. Diplomatic intervention versus U.S. sovereignty. After the raid, South Korea's consul general was sent to Georgia to support nationals. Consular officers can secure counsel, humane treatment, and repatriation, but cannot stop deportation orders or erase violations. U.S. sovereignty prevails. Unauthorized employment leads to deportation and long-term inadmissibility. A repeated pattern of compliance failure. This is not an isolated occurrence. It is part of a wider structural pattern identified by BBIU. ESTA privileges at risk. In our earlier report, South Korea at risk of losing ESTA privileges, we documented how Korea's high visa denial rate, frequent ESTA overstays, and over 5,400 deportations created a compliance profile that placed Korea at risk of losing access to the visa waiver program. The issue was not only U.S. policy pressure, but lack of meticulous compliance by Korean travelers and institutions. Industrial enforcement, Hyundai/LG raid. The Georgia raid shows the same weakness, sending workers on business visas to perform tasks requiring employment visas. Political scrutiny, FARA and CAPAC. DOJ reviewed a Korean-American advocacy group for possible FARA violations. Again, not U.S. arbitrariness, but weak compliance. Strategic implications. Compliance gaps become U.S. leverage, eroding safe harbor perception, damaging Korea's investments, and exposing diplomatic vulnerability. BBIU final opinion. The Georgia raid crystallizes a truth BBIU has warned of repeatedly. Compliance is not a technicality, but a strategic defense. South Korea's failure to internalize U.S. regulatory rigor in ESTA, in visa compliance, in FARA disclosures has created a systemic vulnerability. The United States is not manufacturing these vulnerabilities, it is exploiting them. Unless Korea adopts radical compliance discipline, every investment, advocacy group, and diplomatic engagement will remain exposed. The message is clear. In the U.S., legality is leverage. Meticulous compliance is survival. Annex corporate responsibility and U.S. legal enforcement. The Georgia raid is a compliance failure by Hyundai and LG. Both firms allowed workers on B1, B2, or ESTA visas at a U.S. site where employment visas were required. Proper categories, H-2B, H-1B, L-1, E-2, are well established. Choosing shortcuts created the conditions for enforcement. Hyundai and LG now face delays, reputational damage, and future visa risks. U.S. legal authority and sovereignty. The enforcement action must be placed in the context of U.S. sovereign right to apply its immigration and labor laws. Every country enforces its own visa rules. In the United States, the system is rigorous and violations are consistently sanctioned. Immigration enforcement targeted unauthorized employment, which is explicitly prohibited under B1, B2, and ST. Visa waiver programs scrutiny arises when overstay and misuse rates exceed legal thresholds. FARA oversight is grounded in statutory requirements for disclosure of foreign-linked political activity. In each case, the trigger is non-compliance on the Korean side, and U.S. authorities acted within their mandate. Concluding note, the lesson from the Hyundai LG incident is clear. Korean corporations must exercise far greater precision in visa compliance and labor deployment. U.S. TAP enforcement should be expected whenever non-compliance occurs. For Korea, the path forward is to strengthen compliance culture to protect investments from disruption.